Well, good morning. I'm Thaddeus Michael, an employment law partner here at Gunner. Thank you very much for attending this morning. We've actually got a really good turnout, so I really do hope that you find this webinar useful. Now, in order to make this as interactive as possible, although that's not easy with the way webinars are set up, please feel free to email me any questions as we go along, and I can address those questions at the end of the presentation. So let's try and make it as interactive as possible. Now, it's important if I provide some context and background to this webinar. Now, I've advised many employees on dealing with workplace issues. So this presentation will give you an insight of what the hurdles are that an employee needs to overcome before they approach their employer on a sensitive workplace issue, whether it's through a grievance, whether it's through an informal meeting. Now, for the HR employees out there or HR managers, this will give you an insight in terms of how you should react to the types of issues that are raised by the employee, because you know what they've had to go through to get to that stage. And also, as I've advised on errors employers have made when dealing with these issues, and then I've used them to my client's advantage. Recently, I was instructed against a multimedia company on a disability-related discrimination claim. So it's an associative disability discrimination claim. And in this instance, my client had raised a grievance on the basis that she'd alleged that her line manager had treated her less favourably because she couldn't be at the office as during the times that she was contractually normally bound to be, because she had to look after her terminally ill husband and attend hospital appointments. Now, irrespective of the allegations that have been raised because of the treatment that she received at the hands of her line manager, the investigating officer in the investigation report themselves stated that the line manager was correct because of the fact that she wasn't attending the office as many times as she normally would or was contractually bound to, should have made a formal flexible working application. And this was something that no other employee was required to do. Now, this is obvious less favourable treatment. Now, either the investigating officer didn't know the law or they hadn't properly been briefed. But I was then in a position to use that unequivocal written confirmation in the investigation report to further strengthen my client's claim. In another case, Human Resources had failed to disclose a material document which would have further strengthened the prospects of my client's claim. Now, after we pressed for disclosure on appeal in the actual grievance itself, once that document came out, the implications were twofold. One, it strengthened my client's case. Two, in fact, they were threefold. Because it hadn't been disclosed prior to that, it reinforced the strength of that email. And thirdly, I could use as leverage the fact that their HR department, where they were a very influential organisation, had basically lied and failed to account for a material document. And that ended up being the strongest argument even out of the other two. And that stems from the fact that what we're going to be looking at in the seminar is making sure that you've got a strategic roadmap before you press ahead with it. I've also advised employers on dealing with grievances and disciplinaries. And I was instructed by an employer to advise on his small to medium-sized enterprise, very successful individual, and he was being sued by his own in-house lawyer. So she knew all the ins and outs of how the organisation worked. She'd put forward a substantive grievance, but because I took detailed instructions from him with regards to her personality, how she would thought he would react to the allegations, we looked at in detail the factual allegations that had been raised, what could be proven, what could not be proven. We looked at also her financial circumstances and how she had negotiated in the past. We then advised on a strategic roadmap in terms of how the grievance would be dealt with, how we would provide information, when we would put forward an offer, when we would ignore any settlement offers that were put by her. And we managed to reduce a claim initially at 180,000, which she was never going to get, down to £10,000 within 3 to 4 months, because it was tackled in a certain way and we developed a strategic roadmap. Now, you may think, how is all this going to be relevant for me? Now, if you're a senior exec, you may be experiencing some issues with your line manager, and you may be requiring advice on how to deal with these issues and deal with them properly and credibly. You may be thinking of raising a formal grievance, and you may want advice on what that actually entails and what are the implications of raising a formal grievance against your employer. Or you may be thinking of taking court action. If that's the case, then this webinar will help you look at what are the basic principles that you need to consider before you do anything. As an HR manager, you will look at this from an employee's perspective, as I said earlier, what hurdles they need to overcome before they approach you, but also from an employer's perspective, and what are the basic principles, again, that you need to consider so you can properly advise your employer. HR managers, in my view, have a very, very difficult job. As a lawyer, my job is easy. I need to present the strongest possible one-sided case to the other party, and I'm not conflicted. I have to act in the best interest of one client. As an HR manager, you've got various hats. You need to protect the employer's position. You need to consider the individual where the allegations have been made against and to what extent they have sponsors, how senior they are, what business they bring in. And also you need to consider the individual that has raised these issues. Ultimately, you want to resolve this in the best interest of the company. So that's not easy. So this webinar will look at what basic principles you need to follow so that you're able to properly advise and properly go forward with a strategic roadmap. Now, it's also important to let you know what this presentation is not going to tell you. It's not going to tell you about or advise you about producing a pristine staff manual or training your managers on the staff manual, on equal opportunities, on maternity and paternity leave provisions. It's not going to give you specific advice on how to do an investigation report. It's not going to give you advice on how to produce a proper disciplinary procedure and implement that disciplinary procedure. It's more to do with how you determine your strategy when dealing with sensitive workplace issues and what those sensitive workplace issues are. So, as a starting point, let's look at what our basic do's are. And this is what we're going to expand upon during the course of this webinar. First and foremost, whether you're an employee or whether you're an HR manager, you need to work out what the objectives are. And we're going to look at that in more detail. As an employee, do you want to continue working? Do you want to exit? As an HR manager, is the person making the allegations a key employee or not? Have your employers wanted an excuse, possibly, to terminate their engagement? Is the person against whom the allegations are being made a key employee or not? What are the severity of the allegations? You then need to work out the factual and legal issues. You can't adopt and advise on options or a strategic roadmap until you look at the facts, until you determine or provide at least a preliminary view on what facts can be ascertained and what facts can't be ascertained, and whether there are any legal implications as a result of those facts which could lead to court action, and what type of court action. You should also be looking at the costs and other implications of taking a specific course of action. So if this continues, what are the costs going to be? You've got a budget. As an HR manager, you'd be doing your job by advising the employer what the costs are going to be and what you've got in place to protect the employer against the costs. Also, implications of specific course of action. If something is going to happen over a course of a period of time, are there going to be any reputational damage that your employer needs to know about? Fourthly, you need to work out what funding arrangements. An employer will need to organise their funding arrangements before they take any action. And I will look at that in more detail. As an employer, what actual funding options do you have in place which protects you against any claims by employees? We're not talking about professional indemnity insurance or public liability insurance. We're talking about insurance against employment tribunal claims. It's completely different. Then once you've looked at numbered items 1 to 4, you then work out a strategy based on looking at all 4 points. Okay, now, basic don'ts. And you'll probably see throughout this webinar that the advice that I give is actually annoyingly simple. But if we're an employee with issues that are creating emotions, or we're an HR manager who needs to look at a very serious case with significant implications, or we need to protect a certain individual, high-level individual within an organisation against difficult allegations raised against them, or we're in a new position, or we're slightly outside our comfort zone, sometimes we forget the basics. And this is what this webinar is all about. Now, first and foremost, do not underestimate the issues. So many times have I seen HR just advise quite quickly on performance managing an employee, and this can lead to significant claims up to discrimination if that performance management hasn't been carefully thought out. So at the same point, as an HR manager, don't take someone's word for it. It doesn't matter how senior someone is. You need to cross-examine on points. You need to cross-examine before someone approaches you and says, this is what's happened, or defends some allegations. So if a senior line manager or any line manager approaches you on advice on a performance improvement plan, look at the whole context and background, not just 1 or 2 areas. They may be subconsciously biased. Never make assumptions. Cross-examine and question on every point. That's basic as an HR manager and as a lawyer. And then do not commit to anything until you have followed systematically the basic do's that I've previously looked at under items 1 to 4. Now, before we expand on the basic do's, it's important that we actually look at what are sensitive workplace issues. Now, we've got the obvious. Any allegations involving discrimination, so discrimination because of sex, sexual orientation, because you're transgender, because of your religion or beliefs, because of your age, because of your disability, because of the fact that you've blown the whistle. Now, these are clear, significant allegations against an organisation which can lead to potentially unlimited claims. But there are also other less obvious workplace issues that can escalate into significantly serious issues if they're not addressed correctly from the beginning. And they are perceived unfair performance ratings, even from an appraisal. Subtle bullying. So, slowly freezing an employee out. Failure to promote. unfair selection for redundancy, personality clashes between two senior employees, two employees, or a line manager and employee. Again, that can escalate into significant claims. So when we look at what is a sensitive workplace issue, my view is that every workplace issue is sensitive and is a potential catalyst to be something much, much stronger and more serious. And I've seen that from its infancy when I've advised on a strategic direction for an employee who then 6 months later may turn a simple, what they perceive unfair performance management to a significant and discrimination claim with significant reputation issues and significant commercial time that has to be allocated in dealing with them. Now, what's also important is to look at what are the basic options open to an employee. Because once HR knows these are the 3 things an employee can potentially do, they can organise their strategic roadmap depending on what forum the employee chooses and why they've chosen that forum. Now, the severity of their allegation will, in some instances, force the choice of forum. However, there are 3 things an employee can do. 1, do nothing. And we're going to look at instances where they may not do anything. But they will not be doing something officially. They will certainly be taking notes in order to promote or strengthen what previously may have been a weak claim. Secondly, they may request to deal with the matter informally, so request a face-to-face meeting. Now, that should give HR an insight that that individual, certainly at this stage, does not want to take action in terms of going for a claim. So that is where HR has a significant responsibility to ensure that all the affected parties have a face-to-face meeting and any issues are dealt with properly, and there's a follow-up meeting to resolve it and a further follow-up meeting to resolve it. An employee can raise a grievance. Now, once an employee's raised a grievance, in my view, look into litigation. So then at least HR knows we've got now X, Y, Z that we need to do to short circuit this or to minimize the impact of this. Okay, so let's look at, firstly, objectives. So if you're an employee, what are your objectives? If you're intending to leave your employer, or you're intending to leave the profession that you're in, period, and you've got a strong enough claim, and you've been properly advised, chances are you're going to go straight for a grievance. And that needs to be a substantive grievance. If you're intending on staying with the employer, then the chances are you will be looking at resolving this issue within an informal forum, which is what we've looked at earlier. So this gives HR, although it seems pretty basic as our starting point, an insight into what are the intentions of the employee, depending on what forum they choose to raise the issue. Now, if you're an HR manager as an employer, is the person whom the allegations are being made against a key employee that the employer wants to retain? Are the allegations is the person who's made the allegations a key employee that the employer wants to retain? That's your starting point. And if you're advising the employer, these are pertinent and extremely significant questions you need to be asking as HR. What are they bringing into the business? Do they have sponsors? What are the implications of them leaving? And that will affect how you deal with potentially any issues they raise. Will you take a more conciliatory, more sympathetic approach? If they're not a key employee and they're an employee who don't perform, who don't have major accounts, who maybe don't have a qualifying period for unfair dismissal and are not raising any discrimination claims, or have weak assertion that they're putting forward, then you may deal with this in a more robust way so that you can promote some form of exit. And obviously this needs to be carefully, strategically positioned, either under Section 111 or, in this instance, you can justify on it without prejudice off the record conversation, have a separate meeting to see whether or not one can agree an exit. Obviously the timing has to be considered here. Thirdly, you've got to consider, sometimes objectives cannot be relevant because if this is such a serious allegation that's being made, harassment, victimization, serious allegation of whistleblowing, then whether or not someone is a key employee or not, you have to treat the case extremely sympathetically, extremely carefully, because all the correspondence is open and it's likely that this will be litigated. Okay, so you've looked at your objectives. You then need to look at what are the factual and legal issues. How can you advise on a strategic roadmap when you haven't examined on the facts, when you haven't questioned on the facts, and you haven't looked at how those facts can be implicated within a legal claim against the employer? So, if you're an employee, the first thing you need advice on is, do you have a strong factual and legal claim? If you can assert specific facts which you can back up either within context or within corroborative evidence, and at the same basis can establish a legal claim on those, then you're more likely to want to raise a grievance. Because if the allegations are serious enough, you're not going to want to maintain your employment with the employer. If you have a strong factual but not legal claim, then if you haven't got a strong legal claim, why would you be putting forward a grievance which will create a lot of issues and maybe lead to an ultimate termination of your employment? In this instance, there could well be strong factual evidence of a personality clash, which there's not enough evidence to establish some form of constructive dismissal, or it's not sort of conduct based on a breach of any protected characteristic. So in that instance, you may say, okay, I've got a credible factual claim. Let's roll our sleeves up and let's have a face-to-face informal meeting. HR will be aware of that. But if you have a weak actual and legal claim, then the best advice is, you think something's happening, you think you're being treated unfairly or less favourably, there's nothing here to corroborate or provide or contextualise, so you do nothing, but you continue writing up your notes until there's some substance there, and then you decide on what proactive action you need to take. As an employer, do you have a strong factual and legal defence? The first thing you need to advise as an HR manager, don't allow people to bulldoze you into these are the issues, this is what we need to defend, I don't care what the position is. Because then you're not doing your job in advising the company or the legal entity what the risks are. Your job is to say, I've cross-examined on the facts on what we've got at the moment. I've questioned on the facts. These are the facts as I see them and what could potentially be plausible or one can establish. And these are the legal issues. Once you've done that as an HR representative, you've done your job. And then you can give proper advice to the employer, and then it goes to the employer to make a decision based on the information and advice that you give, and you give the options. As an HR manager, you've also got to think of, are there sensible topical issues? You may be HR manager for famous restaurant where there may have been an error in a sauce that was provided to a particular religious group, which you, as a company, confirmed was fine for them to consume, and then you subsequently found out there was an ingredient in that sauce was against their religion. This has happened to me, and I use that as a negotiating leverage for my client. Or are there topical issues? This is a sexual harassment claim, which now can create significant reputational damage to the employer. And these are issues where you would determine to what extent you try and get a deal done or not. It may well be that the employee raising the allegation of sexual harassment is not on a significant salary, and you may be better off doing a deal at 6 months' pay if they're not alleging some form of personal injury, and finalise it. But you give those options once you've considered the issues. Is it a factually and legally weak defence? If that's the case, then really you've advised. You say, well, we're not going to back down on something that's spurious, on something that cannot be corroborated, on something that cannot even be contextualised. So then you advise on your strategic roadmap based on that. And that's your significant value add. Okay. So once you've looked at and determined the objectives, once you've considered the factual and legal implications, you then look at the costs and implications of taking a course of action and the funding arrangements. So as an employee, what does an employee do? And this is important from the employee's perspective, and also HR needs to undertake this budgeting exercise. What's the prospective value of any claim if this went to an employment tribunal? Assuming prospects. Okay, so prospective value is X. What is the cost to litigate? Are the costs proportionate to the potential outcome on a compensatory award or not? If they're not, it's unlikely the employer is going to want to go to court. Is it potentially such a significant claim that an employee can find a good employment lawyer to take this on a contingency fee based on a no-win-no fee? That's what you need to account for. This is what you, as an HR manager, you need to incorporate within your advice. Does that employee have funding arrangements in place? Do they have legal expense insurance, which will pay £50,000 to £100,000 to litigate? Is this the type of case that would go to the High Court if it's a breach of a contractual fixed term or some other form of covenant? And does that employee have after the event insurance to protect them against an adverse cost order? Is it a big enough case where a lawyer has taken this on, and a good lawyer, on a full contingency or a part contingency fee basis? So these are all considerations that HR should be thinking about when they receive even a grievance. As an employer, as an HR manager, you should be advising your employer what's their cost exposure. Is there a case in the employment tribunal where, even if potentially it's a weak claim, even if it is, that you have to pay good lawyers significant hourly rates to defend without any prospect of recovery? What's the compensatory financial risk exposure? So, is this a limited claim for unfair dismissal? Is it a limited claim for breach of contract? Is it a limited claim for a basic award? Is it an unlimited claim for discrimination claim or a whistleblower claim? Are there issues with regards to significant aggravated issues? So, injury to feelings, aggravated injury to feelings. Is the individual claiming personal injury? How many years are they claiming they're going to be out of work for? And what funding do you have in place? If you're an HR manager and you're advising a small to medium-sized enterprise, you should have legal expense insurance where you pay a certain amount of money every year, which is less than what you think, so you're covered for up to £250,000 per claim per employee. And then you can give proper strategic advice on what you do because you've prepared for a contingency if you then need to go to court. And then your lawyers will be paid by the insurer to defend that action for you. That's significant. So if you don't get anything else out of this webinar, check whether you've advised your employer on this insurance funding. And if you have any questions on that, please feel free to contact me and I can put you in touch with an appropriate broker who can assist. So, we've considered the objectives, we've worked out the factual and legal issues, we've also looked at the costs and implications of proceeding or defending a claim. So let's look at some examples. These are taken from real life cases. An investment banker wants out of their employers, wants out of banking, so they have nothing to lose in terms of reputational damage. They're claiming race and sex discrimination on the basis that they haven't been promoted and other comparators not as good as them have been promoted from different ethnic backgrounds and who are a different sex. They're also alleging inappropriate behaviour of colleagues when out networking and not being invited to networking events. They're alleging personal injury for 2 to 3 years. That's a difficult claim for an HR representative to defend because the chances are the individual that the allegation is made against may well be an influential person, may well hold big accounts, may well have their own clique around them, like a playground dispute, which they would need to retain. And HR needs to then handle this very sensitively and robustly in terms of a defence. So that's where it's important that they consider a strategic roadmap, as I advise, commit on prospects, and also really press on disputing the personal injury and disputing that report. That's really where you want to minimise the risk in terms of compensatory awards. Another example, an engineer who's been working for an organisation for 20 years, is not particularly litigious, wants to remain in the organisation but has a personality clash with a new manager. Now, it's not enough to justify some form of constructive unfair dismissal. This individual is on 90,000 a year, so really no benefit just to take a claim for 1 year. Wants to maintain their job. Chances are they will ask for a face-to-face meeting and ask for the matter to be dealt with informally. If that's the case, then HR have a significant obligation to arrange that meeting, arrange an appropriate agenda for that meeting, manage that meeting, brief the person who the complaint is against before that meeting in terms of how it must go, organise action points, and then put forward a plan whereby there's a proper follow-up. Now that's where HR has a significant responsibility because now it's up to them to manage it and not allow it to escalate. Now, what about defending allegations of unfair performance issues, which I'm going to look at in more detail in the next slide. What an HR manager needs to do in this instance is, even before it gets to performance management, make sure that they are clear on why the employee is being performance managed, what are the performance management issues, and the context and background to those. There's no point just highlighting one or two performance issues when the employee has performed very well on other areas. At the very least, where they have performed well, that has to be highlighted so you can justify why you're concentrating on one of the two issues. This can seriously escalate, and we're going to look at that in the next slide. Defending allegations of sexual harassment. Look, this is a real serious strategic positioning from an HR perspective. And I've dealt with some very, very good HR managers on this who, rightly so, nipped something like this in the bud, and all parties moved on. In this instance, it may well be that the allegations are substantive. The HR will need to look at, not necessarily be concerned about the more salacious allegations, but be concerned about the allegations where there's clear non-consent from the alleged victim. So they need to really look at that in detail, look at where there was non-consent, where there was consent, if relevant, and then look at really, is this something they want to resolve quite quickly? If the employee is asking for 5 to 6 months, do they really want to go to a formal grievance and nip this in the bud? So again, as an HR manager, they will need to follow the basic principles. Once they've followed those basic principles, then advise on options and course of action. On defending a disciplinary, I've really looked at it from a performance management perspective, because the reason why I've done that is historically I've always been successful in claiming unfair performance ratings on behalf of my client, in this instance the employees, either through a performance rating having to be adjusted, so that's a success, that's the exception to the rule, or in fact this leading to a pretty good settlement sum, either through unfair treatment or through some form of discrimination, for the pure fact that the HR manager, when advising, has not looked at carefully what the performance management issues are and whether they're justified. From an employee's perspective, they know how they've acted. So my job is very easy as their lawyer. Give me substantive points on what you've done this year and why 2 points have been pinpointed. And then once you run that argument and you create doubt in terms of the logic and reasoning of the performance improvement plan, that creates significant issues for the employer. And then the employer has to seek to justify and backtrack performance improvement plan, which should never have been permitted in the first place. So in that instance, HR's responsibility is significant in terms of giving proper advice to the line managers when the line managers approach to performance management before it escalates any further. Okay, well, that's the webinar for today. Thank you very, very much for those who listened in. This will be streamed, so hopefully there'll be further relevant individuals who want to listen to this. And if you have any questions, even if you haven't heard this live, please feel free to contact me on 07971 000048 or email me on thalis_vlachos@gunnercooke.com. So THALIS_Vlachos, V for Victor, LACHOS @gunnercooke.com. Thank you.